Good afternoon. Welcome to Agenda Review for Tuesday, February 17th at 3:19. Again, this is not a vote-taking session. This is discussion items only. So, Madam Clerk, if you will call the roll.
Commissioner Rawls.
Present.
Commissioner Durrett. Here. Commissioner Oster.
Here.
Commissioner Jackson. Here. Commissioner Russell. Here. Commissioner Hill.
Here.
Commissioner Lee.
Here.
Commissioner Thompson.
Here.
Commissioner Fox. Here. Commissioner Jay.
Here.
Commissioner Frazier.
Present.
Thank you. We will open it up for any discussion, commissioners. Any agenda items? Commissioner Durrett?
Thank you, Madam Chair. One question, Commissioner Fox, will the language for, I've lost it now. The 287, the item number 34, be posted? Do we have that language?
Are you talking about the issue with handgun carry permits?
No,
The
the
287G.
287G task force model?
No, I asked that that be withdrawn, I thought.
You moved it to February from
Okay.
January, so
Yeah.
are you wanting that withdrawn?
Yeah,
Okay.
I'm not going to
okay.
pursue that,
Okay.
at this time anyways.
All right, so let's just mark that number 34 will be removed. All right. Commissioner Fox, do you have?
Oh, no.
Okay. All right, do we have any other items to discuss?
Continuing on that, do we have the resolution for number 41?
And that's for the self-defense.
Yes, I attached that, or I provided that to Ms. Rosberg, and that should have been uploaded, was it not? It should have been, it should have been loaded with, what is it, Agenda Quick, because I provided that by Wednesday of last week, or Tuesday of last week even. So I do intend on amending it slightly on the floor. I want to make it so that every day that, Commissioner Jackson, do you want me to elaborate a little bit since you inquired about it? Okay. I intend on amending the language slightly so that every day that, like a third-party lessor or lessee of the county would be in violation of this, that would be a $250 fine every day, okay? And the reason why I was so interested in the East Tennessee Museum during Director Caldwell's presentation is actually what spawned me or elicited my providing this proposed ordinance, because right now, the East Tennessee History Museum, or Museum History, the facility, in my opinion, is improperly posted. It has, I went there a few weeks ago, Commissioner Rawls was there in a presentation about, and I noticed that the posting prohibited all firearms on that, in that facility. That, under the current state of the state law, that is an improper posting because there was not a law enforcement officer and a metal detector at every entrance. So the way the state law reads, and I'll be happy for Mr. Moyers to weigh in after I speak, because I believe this is correct, though. There are basically three tiers of county facilities. There are, when it comes to carry permits, and just carrying a firearm in general, or a handgun in general. Tier one is the state specifically prohibits any firearms other than being carried by anybody other than law enforcement by statute. And so an example of that are buildings in which judicial proceedings are taking place, school buildings, et cetera. That's tier one. The state controls that. Then you have tier 2 and 3, as I would describe them, and they, whether or not someone with an enhanced carry permit or just a concealed carry permit, those are two separate types of permits that allow the carrying of a handgun. Whether or not people carrying those firearms are also prohibited in these non-statutory prohibited facilities depends on whether there is a metal detector and a law enforcement or private security guard posted at each entrance. If those facilities have a law enforcement officer or security guard and a metal detector posted at each entrance, then all handgun carriers are prohibited from bringing their handgun into the facility, and only law enforcement can carry. Otherwise, people with enhanced carry permits and concealed carry permits can carry their handgun on the property. And there's a different kind of sign that's required. So you have this kind of intermediate level between state prohibition and county prohibition. Well, in my opinion, the East Tennessee History Museum's facility is improperly posted because it prohibits all. And it should say that only people with enhanced carry permits and concealed carry permits are authorized to bring a firearm. Now, and I took a picture so I can look at it, but I'm pretty sure that I'm relating that correctly. So I want to make it clear that lessees of county facilities have to obey these laws because the statute is mandatory upon the county. And counties cannot extend any greater right to a third party than the county itself has, or any greater authority. So if the county is restricted from preventing or prohibiting people with carry permits from bringing their handguns onto the facility, then the third party lessee is also restricted from that. And there may be some kind of miscommunication, so I want to make it clear, instead of somebody having to go through these gyrations, I just want to make it clear to a potential third-party lessee and the county, for all these facilities that may not fall under the statutory prohibition, about what their responsibilities are with regard to people's right to self-defense. Now, there is one exception to all that, and that is libraries. Libraries, under the state statute, don't have to have they are not statutorily prohibited, like the state has not said you cannot bring a handgun into a library, but they are exempted from that tier system that I talked about. So somebody could simply make a policy that you can't have any handguns in a library. But Mayor Jacobs chose to effectively create an executive order that says, no, people's right to self-defense does not end in the parking lot. They can take their handgun into a library, and I want to codify that. So that's the other part of this particular initiative.
Does the county legally have the right to enforce it upon lessees?
Yes, that's what I was explaining.
Yeah.
There's this doctrine called the non-delegation principle, which if the county has certain restrictions on its ability to prohibit the carrying of a firearm by an enhanced carry permit holder onto a county facility, that same restriction applies to the lessees of the county facility. And again, that's called the non-delegation principle. And I listed a citation or two in the ordinance itself. And Mr. Moyers, did I give an accurate recital of the law?
3917-1359 is the statute that allows entities to post that there are no firearms allowed in the building. There's a subsection G that says, except as provided in subdivision G2, nothing in this section shall authorize an entity of local government or a permittee thereof to enact or enforce a prohibition or restriction on the possession of a handgun by an enhanced handgun carry permit holder or concealed handgun carry permit holder on property owned or administered by the entity. And then unless the following are provided at each public location, says metal detection devices, at least one law enforcement officer or private security officer who's been adequately trained to conduct inspections, and that each person who enters the property through the public entrance when the property is open to the public and any bag, package, or other container carried by the person is inspected by a law enforcement or private security officer described in subdivision G1B, or any unauthorized representative with the authority to deny entry to the property. So the interesting thing about that language is it says that no local government, no entity of local government or a permittee, and that term is not defined. Now, when you read it in the context of the statute, it's hard to see permittee not being somebody who leases the building from the government. I don't know what else a permittee would refer to there. And if that is the case, then the whole delegation argument really isn't necessary, because anybody to whom we lease county property would be a permittee. So if you're reading it, if that's what it means, and if I've not found any case law that interprets it, but if that's what it means, then anybody who leases a building from us must follow this rule. And so that's where we are. And I think, and Mr. Fox is correct. He did send us the language of that ordinance. I never send stuff to Agenda Quick. I assumed it had gone to, is it there? Okay.
there.
So anyway, welcome you to read it, but that's what the statute says. And as I say, if an entity who rents property from us would be considered a permittee, then they would have to follow those rules as well. So,
Commissioner Durant?
Thank you, Madam Chair. Commissioner Fox, is this an isolated incident, or have you seen this in other, I guess, lessees of the government or any kind of government entities?
I would say this, I've not gone out and attempted to inspect other properties, but I think it's necessary to clarify it. I don't think that somebody should have to file a declaratory judgment action to help lessees and the county itself to understand what the obligations are with regard to people's right to self-defense. And then the law, I mean, I think this particular law, if I recall, it changed in 2020. But, the law has changed quite a bit in the past 10 years. And so, there were some issues that arose in 2019 that I was a part of that somewhat. And so I think it's just important to clarify to third parties that they need to follow the statutory law. Yeah.
Okay, thanks for that clarification. I was just curious that if this was one isolated incident, that if, as you stated, the law has changed a lot in the past 10 years, maybe they just haven't changed their sign. If anyone has actually talked to the East Tennessee Historical Society and it's just been an oversight and not like they're intentionally not complying with the law. So I don't see that to be the case. I would assume that isn't the case, that they are intentionally refusing to follow the law. I guarantee it's just a clerical oversight in this situation. And I mean, I don't know that an ordinance would be maybe it just comes down to enforcement. So maybe it's more of a, oh, well, I saw this. Who do we need to send to help and tell them that, hey, the law has changed. We need to update your sign. And it'd be that simple. Just a thought.
I appreciate that. I think, Commissioner Durrett, that there needs to be, because the enforcement of it is entirely reliant upon the goodwill. And I'm in no way denying what you're saying. It could very well be exactly what you said. But at the end of the day, enforcement of the ordinance or the current state of the statutory law is down to the goodwill of the property owner and the lessee. And if no one feels particularly motivated to follow the law, then the only recourse is to file a lawsuit. And I don't think that a law-abiding enhanced carry permit holder or concealed carry permit holder should have to go to those lengths. And so what I'm doing here is providing a remedy for them, and hopefully they never have to pursue that. And if these property owners are obeying the law, then they have nothing to worry about. And also, by the way, I gave a 30, if you look, I gave a 30-day window for people to become compliant. So this is not about like, ambushing somebody, but this is it's to put a stake in the ground, say, we want to make sure the rest of you all understand this ordinance and your duties under it.
So one final thing, you had mentioned that you're going to amend this with some, fees per day. Are you going to include kind of a corrective action period and say, hey, upon notice that this is in violation, they have so many days to correct it before fees start to collect?
I wasn't planning on doing that. I'm giving a 30-day, or, if the body, it pleases the body to adopt this ordinance, then it would have a 30-day window to allow lessees to become compliant. And then after that, then it's just.
And that's when charges occur.
Yeah, well, or they get sued, and I put a provision in there that it's called a fee shifting statute. So if somebody if somebody is obstinate and they got to get sued, then the person who files the lawsuit will get their attorney's fee paid by Knox County. Now, you may say, well, why would anybody do that? It happens, man. That's all I can tell you is you get there have been many, many times, for example, when municipalities and counties get sued because they don't understand the proper boundaries of the First Amendment when it comes to religious expression. And they get sued, and you get some principle that says, you can't bring your Bible on school grounds or something like that. I know it sounds ridiculous, but it happens. And so there are provisions to help teach the lesson for those who just are ignorant of the law. And unfortunately, you just have to have that in here. Otherwise, it could happen.
Anyone else? Director Moyers, would this be something that, before this goes into effect, that the law department could reach out to each one of the people who are leasing these properties and let them know of this law and that they need to be in compliant before?
Sure.
I mean-
I would just need a list of all the county properties that are leased to third parties. I don't have that list, but I'm sure somebody in this room probably does. So if we can find that, we can certainly make people aware of what their responsibilities are under the law.
Yeah, because it could just be a situation of just not knowing and realizing, and no offense, but if we can keep Knox County from paying attorney fees, I think I would prefer to do that. Commissioner Jay?
Thank you, Madam Chair. Mr. Moyers, I might be backtracking here, and I apologize if so. Can you just help me better understand? This building doesn't allow firearms. Other buildings do.
This building.
Some are in between. I want to make sure I'm clear.
Okay, what the statute says is if it's a building that is operated by a governmental entity and you wish to prohibit persons who have a concealed carry license or enhanced concealed carry license. Tennessee has what's called constitutional carry, where it's legal to carry whether you have a license or not. But these actual permits require background checks and some training and things like that. So if you wish to prohibit people who hold those permits from carrying in a governmental building, then you have to provide metal detectors and security guards at every public entrance. And if you'll look around the building, you'll see that at every public entrance, such a thing exists. There's only two, out there and down there. So that's what you have to do. Now, you could also probably do it in this building without the metal detectors, because one of the exceptions is a place where judicial proceedings are in progress. And so since there's almost always judicial proceedings in progress Monday through Friday in this building, that would be probably an exception in this building. But we've chosen to have those kinds of metal detectors and security guards at every entrance. What this statute says is if you're renting a building from Knox County, you have to do that too. Now, libraries are set out as an exception. There's some recreational facilities that are set out as an exception. Buildings that contain a law enforcement agency are an exception. Buildings that are licensed by the Department of Human Services and administrate a Head Start program are an exception. But apart from those, if you lease property from the county and you wish to prohibit holders of concealed carry permits from bringing their weapons onto the property, then you have to provide those metal detectors and security guards. And I assume that the thought process is if everybody has to go through a metal detector, then you've got less to worry about as far as carrying a firearm in the building.
Is it just buildings or is it facilities? So we have Carnes Sports Park. We also have a Carnes Senior Center right next door. One is a building, one is a facility where people rent it for summer, softball tournaments. So is that the same, where everybody would have to come through a metal detector in order to participate in the renting of the facility as a whole versus, and then would each of our senior centers, I guess that's operated by us, so that's different. But people do rent the senior center out too, I think sometimes for private events.
The statute states that it uses the term property owned or administered by the entity. So that's pretty broad. Property is broader than building. So it certainly could apply to something like the rec. Now, I would say the rec center would not, because as I said, one of the exceptions is properties on which firearms are prohibited by 3917-309 or 3917-1311B. And I think that one, let me get to that real quick. 3917-1311 prohibits carrying any person to possess or carry, whether openly or concealed with the intent to go armed, any weapon in or around the grounds of any public park, playground, civic center, or other building, facility, area, or property owned, used, or operated by any municipal, county, or state government. Now, there are some exceptions, and I really wasn't prepared to speak to all of them right now.
No, that's fine.
But
Maybe I'm getting ahead of myself. I guess I'm trying to figure out how many if of this ordinance, how many facilities are we talking about?
Don't know.
It's hard to consider passing an ordinance about something. It's just until we know what. Are we talking about one of our facilities? Are we talking about 32 of our facilities, or what? How does this? Do you have any information about how many, Mr. Fox?
I don't. I will say that 1311, I believe, is the statute that specifically allows, like, everybody's prevented from carrying a firearm, and then it lists a class of persons who are an exception to that general rule, and one of them is people with a enhanced carry permit or concealed carry permit. But I suppose the constitutional carry, so-called folks, do not have an opportunity. Even then, though, I think in that particular statute, a gun-free zone can be staked off with secured, like, events like Chilhowie Park, for instance, or TVNI Fair, for instance, can be, even though it's a recreational facility, it can be made gun-free because of law enforcement being at the entrances and having a metal detector. That's 1311. But no, I don't know how many facilities. I don't think it's going to necessarily change a lot. I don't know how many facilities are actually leased out to third parties, but the way I view this is just a policy statement that we are making, kind of like Mayor Jacobs made when he proclaimed that libraries, the people inside of libraries could have the right to self-defense. And that's what we're doing, is we're making a policy statement that's going to be fulfilled by the county agencies.
Well, I would just wrap up this conversation. I would like to know how many facilities, because I don't think this is just this is actually a change in the law with punitive and penalties, and I think it's more than a policy statement. So I would like to have some sort of information to consider this further about, like, what facilities in Knox County are we are we trying to, to remedy through, or to, that this would apply to? So I'd like that, to see if that could be figured out between now and first reading.
Director Snowden, do you know? Is EPW in charge of, no? Yeah, Director Snowden, there are some, 30-plus facilities leased, or around the county? Or how many facilities are around the county?
There's a lot, probably more than that when you add senior centers and libraries and all the facilities. There'd be, probably I would say close to
50?
at least.
Okay, all right. All right, thank you.
Anyone else? All right, seeing no further discussion, we will adjourn optional review, and we will be back here at 5 for zoning.